Good afternoon and welcome to today's webinar. My name is Amanda from CCIQ and I'll be your facilitator for today. Joining me is Michael O'Brien. He's one of our HRIR advisors here at CCIQ. I'd like to mention before we kick off that today's webinar is sponsored by CIVS. They are an independent online voting solution that specialise in enterprise agreements. Now, today's webinar is on employee contracts. We all know that employers must regularly review and ensure employee contracts, current and new, are lawful. And reviewing employee contracts is quite a significant task because you also have to consider the relevant awards, enterprise agreements or other arrangements that may apply. So today Michael's going to provide some knowledge and insight needed to properly read a contract and also what to look out for in terms of legislative compliance. Now before we start, if you want to ask Michael a question, you can do so at any time using the chat box that appears on the bottom right hand side of your screen. We have just under 400 people registered for today, so we may not get through all the questions, but we will do our best. So I'll now hand over to Michael to take you through today's presentation.
Thank you very much for that, and thank you everyone for this opportunity to connect with you and connect with the businesses out there. So for those who don't know me, my name is Michael O'Brien. I have about 15 or more years of experience within HR, but with CCIQ specifically, almost 2 years now, almost 12 months now. So I've had conversations, discussions, everything you can think of about employment contracts with so many members. It's one of our most covered topics. I've done everything you could think of, creating, reviewing, as part of all my engagements with members out there. So I consider myself somewhat of an expert on this topic, but as much as anyone can be, because there's always something that comes up that can throw you a curveball in this area. But I'll try and give you as much information as possible to help your business. So what we're going to cover today is what's included and excluded in contracts. What constitutes a lawful clause and unlawful clause? How often contracts should be reviewed? The importance of reviewing contracts for business owners, and how to manage disputes related to contracts, and how Chamber of Commerce and Industry Queensland can help around consultation, contracts and reviews, and all parts of that. So, what to include and exclude in contracts? Well, first off, it might surprise everyone, but there's actually no obligation under law to have a written contract of employment. So the question is, why have one at all? And in fact, that question we get a lot. The question we get is, do we need a contract? Exactly how it's asked all the time. And our response is always yes. In every circumstance, you must have a contract. Why? Well, first off, it's agreement between employer and employee that stipulates working obligation and entitlements. It's a written employment contract. It's designed to protect you, the employer, and that's the most important part. It's really there to protect you, and I'll show you why. Without a written employment contract, disputes over the terms and conditions of employment are likely to arise, and they often do. We've seen it through a number of unfair dismissal cases, underpayment of wage claims, and things like that. That the key piece has been the contract. Without the contract, it becomes a hard slog, lots of money, lots of time outlay to settle the disputes. So employers often have difficulties dealing with employees when there is no employment contract in place to guide the employment relationship. You can have a contract for people who are employed on a permanent basis, fixed or max term, casual, seasonal, or commission. Also, though, if you have sole contractors, definitely another area where you need and must have a contract because it sets out the relationship between yourself and that individual. So an area of risk, and we get a number of questions about this, is the max term versus fixed term contracts. And I'll spend a quick bit of time on this just to cover off an area we hear a lot about and people can get themselves in trouble. Max term contracts, parties of a max term contract agree that the employment will end on a particular date unless both parties later agree to continue the employment or extend the contract beyond the expiration date. However, the parties also agree that employment can be terminated at an earlier date by giving notice of termination. So what we try to make sure is always in all of our contracts, and our templates have this, that there's a clause in there that say either party may terminate by giving, say, 2 weeks notice. As to differentiate between that and fixed term contracts, which is the same as max term contract, except that the parties agree there will be no right to terminate the contract early, except where there is a breach of the contract, for example, based on performance or breach of confidentiality or failure to obey a reasonable instruction, for example. In that case, there is a huge risk around ending them early. If you do it correctly, such as giving the right amount of warnings, following the right process, and you must give a reason why it has occurred, then you'll be safe. But there is a lot of risk to manage there, and make sure you do it properly. And that's where I encourage you to be, anyone who's not a member of ours, to be a member of ours to help you through that process. And anyone who is a member, give us a call if you have that situation. Casual employment contracts. Now, there's been a lot of case law around this. WATPAC, if anyone out there is aware of that, around the nature of casuals. It's vital to have a contract for all casual employees. What it does is it cover off a lot of your risk for employers around this area. It sets out the nature of the relationship. It sets out that they receive their loading, what the loading is for example, in the law of overtime, public holidays, leave, etc. Having that in writing, these are the tick boxes that if it ever goes to the underpayment of wages, say for example claim, because the person's claiming they're actually not casual, they're permanent, having those things in writing, the commission will start ticking those off. Oh, okay, hang on, you've got this, you've got that, you've got this. Well, you know, the nature of the relationship all of a sudden is looking actually like casual. Some modern awards actually give casuals the right to convert to permanent employment. So recently there was a change from the beginning of the year that all employees covered by an award, I think there's two awards that don't have this new clause in it. It's a casual conversion clause, which gives the right for a casual employee to ask to go permanent. Now, there's no requirement for you to do that, and there's lots of ways for you and processes around it to make sure you get the right information, go through that process, consider it, and give the response to best fit your business. So there's no reason to panic. Once again, this is an area that we get so many questions about. We guide members through it about how best. So the answer for us, like different to a lot of other services, is, well, what outcome do you want as a business? Okay, you want that outcome. Okay, this is how you go about achieving that. So what constitutes a lawful clause and an unlawful clause? Well, I'll go into some legal jargon here and try to put my own spin on it. Each party voluntarily takes a legal enforceable duty. So you're giving a contract, you're giving something and taking something. So one party voluntarily takes a legal enforceable duty to work, aka they go there to work, that's the service. And another party takes a legally enforceable obligation to pay wages in return for work. That's the agreement. Each party intends to create a legally binding obligation that are continually and mutual. The employee's performance and obligations must depend on the performance of the obligation. And each party provides consideration for each other's obligation. So some benefit or advantage to the other party in return for their agreement to do something in pursuit of the contract. Essential terms such as pay and the type of work to be performed have to be agreed on, and the contract is certain and complete. So, what constitutes a lawful clause and unlawful clause? So, be mindful that if you breach the employment contract, the employee may make a breach of contract claim, and I'll go into that a bit further. But if you've made an agreement and you try to do something different that outside of the employment agreement, you may get yourself in trouble. If you try to change the agreement, there's nothing under law that says the employee must change that agreement, and you will have some difficulties. A breach of contract will expose you to award damages, the compensation of loss employees suffered as a result of the breach, in order that you may repay monies owed, interest on the damages, debts, sums, and employees' legal costs. So minimum obligations. So an employment contract cannot provide for conditions which are less than the minimum standards set out in legislation, awards, agreements, including national employment standards. So you must know the employees award. And one thing for everyone out there, please, if someone is a salaried employee or on another, or what other people call a rolled up rate, that doesn't mean they're not covered by an award. Most people are covered by the award unless they're very highly paid or they're in a occupation or a job that's not covered by awards. But a big mistake people are making is that they claim everyone's award free or on a common law contract, when in fact they're covered by an award. So please make sure you do that and make sure you find out. So once again, I encourage, if you're not a member, become a member, and that's the first thing you should do. What are my employees covered by, and are they covered? And then you can understand their entitlements and what your obligations are. But underpinning awards is the national employment standards. Now, for everyone out there, please be aware that one of the national employment standards, number 10, is to give the Fair Work Information Sheet at the commencement of employment to every employee. It is a requirement under law. So all employees, whether they're signed a contract or not, are covered by the national employment standards. Even attempting to exclude or avoid the national employment standards by mutual agreement with the employee will have no effect. Among the, or NES, as everyone calls it, is the minimum notice periods, the amount of redundancy pay, maximum weekly hours, leave entitlements, rules about working public holidays. So a recent example of an illegal employment contract, that was one used by an engineering construction company. So following a 12-month investigation into the company by Fair Work Ombudsman, it was revealed that employment contract contained provision which would allow the company to terminate employment if the employee engaged in trained union activities. Now, one of the protected rights within the Fair Work system is trade union activities. You've got a right to do that as long as you're doing it legally. If, for example, just like you've got a right to make a work cover claim, you've got a right to make a bullying claim within the workplace. If you're, even if it's not in the contract and you're terminated for one of these things, you know, you can be in all sorts of trouble within the general protections, it's called, within the Fair Work Commission. And so there's two real jurisdictions in the first Fair Work Commission. There's the unfair dismissal and the general protections. General protections are for those terminating for those protected rights that I was just mentioning, which has no limit on payouts and also has a reverse onus on proof. So it's actually assumed that the employer has done it unless they can prove otherwise. And we're actually seeing a lot more claims within the general protections now rather than unfair dismissal because of those some of the benefits to employees, as I said, such as there is no limits on payouts as there are in unfair dismissal. So please make sure there's the other things we see in contracts are if the employee is injured and can't work, they're terminated, which is another red flag. We see that often in contracts, or their hours, they work 50 hours a week as their ordinary hours. Are they compensated for it? How is it worded? It's all those type of things we see over and over again that we help employers through. So, restraints of trade and non-competitive clauses. Are they reasonable? This is an area of the contracts that we actually get most questions about, and I'll go into it. But obviously, for those out there, that most common restraint of trade clauses are non-compete clauses. non-socialization, non-poaching recruitment clauses, confidentiality clauses. So a restraint clause can be accepted on face value, can't be accepted on face value because the courts will uphold it only if it's reasonable. And that word reasonable is all through fair work, employment law, everywhere. For an example, a court won't enforce a clause that unfairly interferes with a worker's rights to contribute to their own labour. So the courts have some capacity to sever a restraint clause if they find it to be unreasonable. Severance is usually only possible where the clause contains a series of overlapping restraints known as step or cascading clauses. So what that means is that our employment contracts, are one created by our experts within CCIQ, such as myself, our team. And what we do is we have legal partners who will actually vet that and make it all legally compliant. And under the restraint of trade clause, what you'll have is what it call here series of overlapping restraints or step cascading clauses. What it will do is it will say that the restraint period, say, is 12 months, and under that it'll have 9 months, and under that it'll have 3 months, and under that it'll have 1 month. So what it's doing is that it's saying, well, if you go to court and the court says it's unreasonable to say restraint of trade for 12 months for that particular business, for that particular area, for that particular industry, and that's all the tests they'll have. They'll say, no, 12 months is unreasonable. But then they'll go to the next line. Oh, okay, is 6 months reasonable? They'll do the test again. No, but 3 months is reasonable, and that gets upheld. So if you had one date in there, it would cancel, and said it was unreasonable, it would cancel the whole restraint of trade period clauses within the contract. And so that's why it's in there. So IP ownership. If you have employees that create intellectual property as part of their employment responsibilities, then who owns the intellectual property? Now, this is another one we get a lot of calls from, a lot of disputes about, and this is one of the areas, as long as restraints, one of the two areas that we mostly refer things on to our legal partners, because once it gets past a certain point, there's no remedy other than legal remedy. So it's around, you own the intellectual property created by employees during the course of employment. Employee must transfer ownership of intellectual property created during the course of employment. The employee provides you with irrevocable, royalty-free license for use of any existing materials. The employee must warrant that any intellectual property created does not infringe on third parties. That sounds straightforward. But what happens if the person's taking your company's laptop home to do their personal work and design their own personal stuff, and they start selling software designed through your system? Whose property is it? If you write intellectual property well enough, it's your property if they use your tools. If they bring their own personal computer in and on work time are creating and doing stuff, whose is it? Well, if it's created on work time, potentially it's yours again. These are all the things you need to make clear in intellectual property, and this is what our contract templates will have, that sort of detail in there. And that's vital, because you do not want someone to using your, thousands of dollars value worth of software to create something that they go and sell that you're particularly not selling, but it's something similar that they're working on. How often should contracts be reviewed? Well, contracts should be reviewed at least every 2 years. So employers are encouraged to review their existing employment arrangements, including template contracts, to ensure that they benefit to the maximum extent from the learnings above. So, when deciding whether to update contracts, you should answer the following questions. Are your contracts up to date? Do you have the flexibility you need? As in the contracts, do they accurately reflect your current work practice around people's working hours, whether a day worker, a shift worker, how many hours they actually work? Does that include payment for overtime? Have you taken into account the cost of overtime, whether that's paid separately on top of the hourly rate or it's rolled up within the hourly rate? And if it's rolled up within the hourly rate, have you considered any increases in award payments, which is timely at the moment, given that the award increases are about to become effective? So, are your post-employment restraints likely to be enforced? Are your termination provisions drafted in the best way for you? And for example, that was that fixed term versus max term contract. Is a lot of people have in their contracts certain amounts of notice, which is over and above what they actually have to pay, and they don't realise because that's just what they've always done. And executive contracts must comply with the Corporations Act, or you will have to need to seek shareholder approval for termination payments. Not that we have to deal with that too many times being with small business, but it's just something I like to put in there. And what we see a lot is outdated contracts. So contracts from years and years ago that aren't even for the person's current job, current conditions. And what this does is cause a lot of problems, especially as there's a claim for unfair dismissal or underpayment of wages. If they're not reflective of what the current practices are, how can you prove anything? It goes both ways. It's difficult for the employee to prove, and it's difficult for the employer to prove. What it means is time and money figuring it all out, and a lot of hard work. Instead of just producing the contract, you have to do audits, and it takes a lot of time and effort. So please, and it's also vital in say for unfair dismissal cases around the acknowledgement of certain practices. So whether they're a day worker or a shift worker, that can be quite important, whether they're permanent, whether they're fixed term. They can be all, especially if someone's a fixed term versus permanent, one, they won't have any access to unfair dismissal, or permanent, they might have access to unfair dismissal, or the contract might stipulate your pay is over 140,000 per annum. Well, if that's the case, you're a high income earner and you don't have access to unfair dismissal. If you had a contract that said that and they've signed it, and you could produce that to the commission if there's ever a claim, it's going to save you time instead of auditing 12 months pay and trying to demonstrate that their pay is over 140,000. Especially if they've got other benefits that they say if they earn 130,000 and you're trying to put a car park, cost of a car park or a car allowance and all these things, trying to roll it up, it gets messy. But if you had that contract, it would solve that problem. So how to manage disputes related to contracts? Well, flat out, contract breaches gets managed through the Magistrates Act or the Magistrates Court. So employees can make a claim through that court and take action against you, the workplace. So be aware of that. And I also use and you'll see there, the high income test to whether they get access to that. But just that's purely about breaching the terms in the contract. So, for example, if you don't pay out someone the required notice that's in their contract, they could take you for underpayment of wages and in the magistrates court. So you always have to be aware of that. But there are other things, so straight breaches of award conditions or something like that, or not paying them enough, that gets treated by the Fair Work Commission. Underpayment of wages. Now, where underpayment of wages happens a lot is not understanding if someone's covered by an award. So they'll see that someone's covered, you'll find out, or you're not aware that they're covered by award, and someone will leave the organisation, all of a sudden you have a claim on your plate, and they've claimed they're on an award, and they're not being paid what they're supposed to be. But you weren't even aware what they were supposed to be paid. So that's where we see underpayments a lot, and then you have to go back and audit everything, and then go and deal with that. So that's why it's key. I can't emphasize it enough. Understand whether your employees are award or award free. Have a contract that tells them what their award is, and have an understanding for your side within payroll what they're entitled to and what they should be paid. Because people in the organisation could be doing one job and then another job, and they could be on, and when they're doing those, they could be on 2 different awards. You could have 3 or 4 different awards in one organisation. One organisation I do a lot of work for has 7 different awards covering their business. So it's vital to understand that. They have different allowances, different practices regarding hours, breaks, all those type of things. And also unfair dismissal and gen protections. They're the other 2 areas I keep mentioning about disputes as well. Another area of disputes is around discrimination. So, pregnancy, sex, race. That's area within Queensland. Sorry, I wanted to mention that Anti-Discrimination Commission. So the Queensland Industrial Relations Commission deal with those sort of cases. So dispute resolution in the workplace. So if you do have disputes, there's 2 types of disputes. There's disputes, conflict disputes in the workplace, or disputes over entitlements, contract terms, something like that. Well, we do have trained nationally accredited mediators to help you with that. So we do offer that service as a fee for service, which people have been taking advantage of to help within the workplace and set with that future relationship in the workplace and resolve those type of things, which has been working well. So how can CCIQ help? Well, we have, as a team here, myself, I have over 15 years experience, but I have, with my team, a lot of experience around employment contracts within all industries across Queensland. We can develop customized templates, analyze and make recommendations on contract templates, and assist bidders to manage contracts in the transfer of business. A transfer of business can be a very complicated area of the law regarding what counts as a transfer of business. When do you or do you not have to transfer someone's leave liabilities across? When a service end and start? Do you have to pay redundancy, or can you get exemptions from redundancy from the Fair Work Commission? Depending how you do those things, all of those things will have people ask, and can be very complicated. So as part of that, our membership has a number of benefits if you join up as a people manager or HR assist level. We can, when you have a contract, we can quickly review it, run our eyes for no extra cost, run our eyes over it for 10 minutes, and let you know if there's any red flags or any areas that stand out to us we think is risk, and let you know then issue update or not, and work with you then to engage with us to either slightly amend, or if you do want to do a further fee for service to create new templates or amend your current templates, we can help you do that. So.
Excellent. Thank you very much, Michael. We do have some questions. First one, what about workplace policies such as social media, drug and alcohol, and bullying? Should this be included in the contract?
Good question. The answer is always no, keep them out at all costs. So what you need to do is you can have a sentence or a couple of sentences in the contract template that the employee must abide by all policies and templates of the organisation. So that's all you need to put in. Keep separately your social media, your internet usage. All of these are key, and say for an unfair dismissal, once again, you need your contract. You'll need your social media policy, your internet usage, your motor vehicle usage, if someone's been speeding or whatever they've been doing. So the commission can see that what your practices are, and that person's been trained and agreed to those practices. And you then can change those policies and procedures anytime you want without having to change the employment contract. If you have it locked into employment contract, If they don't want to change, they don't have to change, and then you've locked into a contract dispute. So be very, very careful. That's why we say always keep it out. And if you do have it in, I recommend you contacting us to help maybe change the templates and massaging that around and talking to your employee about changing that, because practices change every 12 months. Just social media could change at the moment, so you need to be aware of those type of things.
Okay, is an enterprise agreement the same as an employee contract?
No, it's not. Enterprise agreement sets out the terms and condition of your organisation, the entitlements the people are entitled to. Contract sets out the relationship between you, the employer, and the employee. It might actually quite be different to the enterprise agreement that you've got in place. It might be over and above. You might have a special agreement or conditions. It also has different things such as restraint of trade, conflict of interest is another one, gifts, lots of other things about the legal framework around the relationship between you and that employee. So that's the difference there.
Okay, more questions, heaps coming through. Okay, question around leave loading and whether they are allowed to exclude it by contract for employees who never work overtime.
Okay, interesting question. The answer is it depends on if they're covered by an award. If they're covered by an award, no. Leave loadings in, or, well, give that with a 99.99% chance that leave loadings in all modern awards. And if it's in a modern award, you must pay it, unless you pay a rolled up rate that compensates them for enough to compensate for the value of that leave. And when you do that, and this is why it's very important to have a contract, we'd say that when you put the hourly rate, this includes compensation for leave loading. So that, and if they sign the contract, there is no argument with the underpayment of wages claims in the commission, because it's clear that you agreed to it, they've agreed to it, and you're covered. Now, for people that determine as award-free employees, you do not have to pay leave loading. There is no requirement to pay leave loading. You don't have to. However, if you have a contract where it has leave loading in there, good luck taking it out. That's all I've got to say. You can have a good conversation and they can say no worries, but if they say no, then you're in a quagmire. You can't change their contract. And if you stop paying the leave loading, that's when they can have a breach of contract and go to the magistrate's court.
Okay, this is sort of around the same area. Can you, with casual workers, can you stipulate in their contract that you would like them to complete a minimum number of shifts over a period of time?
I'd always say no. It's very, very careful, because the nature of a casual is if they're employed shift to shift. So their idea is for a casual, a true casual, they get 24 hours notice. Hey, Mary, someone's just pulled out, or we've got a shift open next in 2 days' time on Wednesday. Can you fill it? If you're talking about a minimum amount of shifts, that's almost giving them a locking them in. You can, if you see an award, the wording around that, they don't lock them in. They say a maximum 38 hours. Basically, is it. It's all the guidance around when they work. You don't want anything that gives the impression that their hours are regular and systemic. Locking them into a number of shifts, it depends how they work. If they're only working for 3 months, yeah, I would say your risk is low. If they're there for 12 months and you're naming shifts, I would say your risk is starting to get iffy. Anything over 12 months and you're naming how many shifts, then I'm saying you've got a risk on your hands and you need to be very, very careful, because there could be a claim.
Okay, another one's come through. They use a contract, a common law contract that they issue to all their staff regardless of the award that they're on. Should they be issuing separate contracts based on each award, or will this common law be enough to cover everyone?
It's a good question, and I deliberately used that term common law earlier in the presentation because there's a misconception around common law contract and how people use it. A lot of people use it for only to cover those on a high income threshold or award free, where some people call all contracts common law. So it can be a bit confusing. But the question, can you have one for everyone? I'd say it depends on what your contract. If your contract is very, very generic and there's not much in it, maybe without looking at it. But it sounds risky to me. You should have. Okay, so if I went into a business and was doing work for them, which I've done for many companies, I would be creating a contract template for each award, for each type. So casuals, there'll be, if they had, for example, that company that has 7 different awards, they have 7 different casual contract templates, 7 different permanent contract templates based on each award, because the ordinary hours are different for each one, and the breaks are different. The allowances are different. One person you may give a uniform to, and you don't have a laundry allowance in the award, and the other one you give a uniform to, and you have to pay a laundry allowance for them to clean their thing. And it's different. One award does, one award doesn't. There's so many tricks to every award. So if you've got one, I would say you would need to do, and also I'd go take it back to, okay, what does your payroll do? Are you paying what's in the contract? Do an analysis. What are they covered by? Does their contract line up to the award or not? But always recommend one template per award.
Okay, it does get quite tricky, doesn't it? Do you have any advice on how to manage if employees don't wish to sign the contract?
Sure, this question's a good one. It often happens. I've been in numerous organisations where that's happened. So it depends what you're talking about. So as long as the person's not being, if it's a new person or a person in the workplace and you're changing their contract. Now, as long as they're not worse off or you're trying to take something off them, then this is where it gets tricky under the law, because technically, if you've given them contract and told them when the new contract's effective and they've turned up to work, they've effectively accepted the conditions of the new employment. As I preface that, as long as they're not worse off, or you've changed it to something that's, can be seen in the eyes a little bit negative or disadvantage them, then they've accepted the conditions. And that's when at court of law, you have an argument to say, no, I can prove, here's the email, they've got the conditions, they acknowledged it, they didn't agree with it, but they turned up the next day. So they're accepting it. So that by turning up, doing the work, they've accepted that they're giving you a service and they're going to get money in return for it. So it's simple as that. They might take a breach of contract. The lawyers argue that no, they've accepted it, and this is why I say time and money. That's all it is. It goes round and circle, and who can prove what? What's the most reasonable, and the court determines that.
Okay, I think you might have touched on this one, but in the actual contract, if they're under a modern award, should you actually stipulate the name of that modern award in the contract?
Yes, you should. It's not a legal requirement, but we'll always say do that. What you want to do is point out to the employee what their entitlements are. And for you guys to set that agreement to be more of a legally binding agreement but before they sign it, to understand exactly what their employment conditions are and what it's based on. Very important. More than just a black and white document as well. I'm about people and employees, so it's about having a good engagement with your employees. If you're open up front and they're trusting that you're giving them the right information, straight away you're on the front foot setting the right conditions of employment, not shying away from that, you're going to have a better relationship with your employee. So for all those reasons, yes, name it and put it in there. And if there's ever a mistake, put your hand up and fix it. It's not a problem. People make mistakes. That's okay.
Okay, so we'll keep going for a little bit longer. I do want to mention though that we've got quite a few specific questions around certain awards and what awards their staff should be on. And we actually are holding a Modern Awards webinar on the 3rd of July. So I might just pop them aside, but we'll be sending links to the upcoming webinars, but it might be beneficial for you to join that webinar on July 3rd. Another question is, this company pays for pre-employment medicals before a person starts work. Are they allowed to put in the contract that they need to pay it back if they leave or there's any misconduct within a certain time?
The answer, quite simply, is no. Because it's an essential part, because you've made an essential part of getting the job, no, it's part of employment. Vicarious liability is in when they're an employee, you're liable for the cost around the employment. So unfortunately, there's no way around that, and we get that question a lot. An example, training, for example, someone has to invest $15,000 in training and person to get an accreditation to do their job. How do they stop someone leaving within 12 months, 6 months, once they get these qualifications, because they can get $50,000 paid more somewhere else because they've got this qualification? It's more around incentives than anything else. That's where, can you some other way around it or something like that? Think of other ways, to do it. But as in, can you require under law? No, you can't.
Okay, and I might just finish off with, where did that question go? Oh, just lost it. Okay, last one. Verbal agreement. So, obviously, that's fraught with danger. But where does a company stand if they've said, hey, Michael, if you meet your targets this year and we do a great job, I'm going to give you a bonus. Does that agreement stand?
Yes, if someone can prove it, if there was a witness in the room and they can state in a court of law that that's what was said and done, then yeah, they can make an underpayment of wages claim or something like that and take you for common law, small claims court or something like that. Yeah, definitely. So be very careful. And I've had it the other way around where someone's made a claim, but an employee's made a claim. However, the 3 people in the room in that conversation all denied it happened and made statements, and so the person lost the claim. But if the other way around, they all said it did happen, they would be up for the money.
Excellent. Okay, we might just finish up there. Thank you for presenting, Michael. Thank you for everyone who's joined us. Once again, I want to thank our sponsors, CIVS, for sponsoring the webinar. They have an exclusive offer for today's webinar attendees, so we'll send that offer out in the email this afternoon, as long as some more information about CIVS. We'll also send out a copy of the webinar recording and slides, and links to our upcoming events and webinars. As I mentioned, we have a Modern Awards webinar on July 3rd, workplace training on June 26th, and we're also holding a mental health in the workplace webinar on July 9. If there's anyone listening that's in the Mackay region, we are hosting an injury prevention management luncheon on the 24th of July. We're doing that in partnership with WorkCover Queensland and the Office of Industrial Relations. It's going to be a really great event and showcase local employers who've undertaken programs and initiatives in supporting return to work and rehabilitation. So we'll include a link to that as well. So lots covered today. Thank you very much for joining us, and we hope you enjoy the rest of your day. Thank you.